Hello, class. This is Professor Daniel Crane. Welcome back to the wonderful world of business law. Today we're going to be talking about contract law. Contract, the shorthand definition is a legally enforceable promise. Contract is a means to get two honest parties to stay honest, put down their intentions, to speak their intentions, write them down, some extent similar to that, and to create an enforceable promise the law would recognize. The law loves to break things down into all different types of groups. Our first type of grouping we're going to be speaking about is express contract. An express contract is one in which the terms are spelled out directly. The parties to an express contract, whether written or oral, are conscious that they are making an enforceable agreement. Important to note here, express contract might sound very formalistic, but it can be oral or written. For example, an agreement to purchase your neighbor's car for $500 and to take title next Monday is an express contract. Very important to know what are the various elements to show that a contract exists. These are the elements that an attorney would need to show in a courtroom to prove that there was a valid contract between two parties. These four elements of a valid contract are an agreement, which you can break up into an offer and an acceptance, consideration, which is something of value exchanged by the parties, contractual capacity, which means the competency, the mental capacity, and able to understand the contract and its purpose, and legality, meaning that the contract does not violate the law or public policy. An implied contract is going to be a contract that is inferred from the actions of the party. No discussion took place. There was no writing between the parties in regards to the agreement, but the parties' actions created the contract. So if I go to Panera Bread and I walk up to the counter and I say, I'll take a turkey sandwich to go, and I walk over, well, of course, this isn't how it works at Panera Bread, but let's say they go ahead and make my turkey sandwich and hand it to me, there is going to be the implied agreement that I'm going to pay them for the turkey sandwich, even though at that point I wouldn't even know what the price of the turkey sandwich is. Oh, by the way, there is this YouTube video right here. It's a good video, and it's in regards to implied contracts, express contracts. It basically just restates in a different way what I just said, but you might find it useful. Question number 1. If a contract's terms require that a modification be in writing, oral modifications are inadmissible and unenforceable. That would be true. Contract implied in law, quasi-contract. This is similar to the idea we were speaking about before, implied contracts. This gets to a different type of contract that springs forth into being. A magic fairy appears in the courtroom and creates a contract that's going to bind the parties. This happens. A quasi-contract comes into place as a result of an equity at law, where the court is trying to resolve an inequity that occurred between two parties and is trying to make one party whole in regards to their detrimental reliance upon the situation. There's a great example here, this second paragraph of the slide. You can pause it and read that if you'd like. Mutuality, mutual promises. We're beginning to think about consideration at this point when we're talking about mutuality, mutual promises. This is the promise, the value the parties are bringing to the table, and how these values are arranged. So the law breaks these into unilateral contracts and bilateral contracts. A unilateral contract is going to be one typically where a person states an offer to an empty space, an empty void, and just allows their offer to flow out there into the public and into people, where they can then act to accept the offer that's made. Some typical examples you would see here would be the I lost my dog or cat reward poster, $50. I lose my cat, I put up the poster, I say reward for $50. That is creating a unilateral offer that I'm putting out there to the public. Someone who wants to take the action to find my cat then will bind me to my promise. Again, there is a YouTube link there for a good video in regards to unilateral and bilateral contracts. Oh, and a bilateral contract is going to be a promise for a promise. It's going to be the more typical contract when you think about it, such as I will sell you my car, you will give me $500. My car, $500, contract between Dan and his best friend, Dan. In a bilateral contract, the consideration for each promise is a return promise. It's a promise for a promise. Unilateral contract is different. In a bilateral contract, the consideration for a promise is a completed act. That is false. That would be the consideration for a unilateral contract. And remember, when I flip to one of these questions, feel free to pause it. If I'm going quickly, just pause it quickly so that you can take your own opportunity to think about it before you hear the answer. But again, the consideration for a unilateral contract is one side is putting out their offer, their promise to the world, and then the other side will accept it through an act, typically being a prize or a reward, something like that. I'm going to move on from mutual mistake. We'll come into mutual mistake a little bit later here. In a unilateral contract, the consideration for a promise is an act. Okay, we're going to come back into mistakes. It's important in a contract to understand that when you're talking about a mistake, that this would be a mistake in regards to the contract, a mistake by one or both parties in regards to the terms of the contract and an important material portion of the contract. If both parties are mistaken about a material term in the contract, then that contract is going to be void. And if one party is mistaken, it can depend, but it might be avoidable. A blank mistake is the result of an error by one party about a material fact. The mistake by one party would be called a unilateral mistake. Mistake by two parties would be called a mutual mistake. A mistake is an erroneous belief about the facts of the contract at the time the contract is concluded. That would be true. Enforceability. Not every contract is going to be a binding contract. Some contracts are not enforceable. For example, an illegal contract. One of my favorite illegal contracts would be a contract to hire a hitman for an assassination for hire. Assassinations are, you might be surprised to find out, illegal. Therefore, a contract will be unenforceable in the court of law. Of course, the court of the hitman, well, that might be totally different in the mob boss's court, but in the United States court, that type of contract is going to be unenforceable, and of course, it's going to carry some criminal liability. Enforceability, the voidable contract. A voidable contract is one that typically is going to be voidable by one of the parties, meaning one party can rescind the contract. Potentially, it can be voidable by both the parties. A good example for a voidable contract would be a contract by minors. Minors in a contract, if it's not a contract for necessaries, which can depend on which state that you're in, but it's important for this class to understand the difference between a contract for necessaries and a contract for other types of goods or items or contracts. Minors will typically be able to void. They will be a voidable contract for the minor with that adult. When the minor reaches the age of majority, they will then have the ability to bind themselves to the contract. They can do this by ratifying it. They might be able to ratify it through particular spoken word by agreeing to the contract, but typically it's going to be by ratification through their actions, kind of an implied ratification, meaning that a minor purchases a car under contract, the age of 16, they drive it through the age of 17, drive it through the age of 18, they're making payments the whole entire time. They reach the age of 18, they continue driving the car and making payments. Those actions would be such to ratify the contract. On the other hand, minor has a contract to buy a car, they've been making payments on the car, ages of 16, ages of 17, age of 18, they decide to stop making payments and return the car, thereby rescinding their voidable contract. Which of the following is true regarding the ability of persons suffering from mental illness to enter into a binding contract? I believe the answer is the fourth one here. Persons suffering from mental illness may have full, limited, or no legal capacity to enter into a binding contract depending on the nature and extent of their mental deficiency. If a minor attempts to disaffirm a contract for the purchase of goods, let me read through the answers here. The answer is going to be A, I believe, quickly reading through these. The extent to which the minor needs to restore the contracting party to that party's pre-contract position varies by state. So for my example where the minor drives the car for 2 years between the ages of 16 and 18 and then returns the car, rescinding the voidable contract, of course, that car will have depreciated over the 2 years. So returning the car back to the adult, of course, the adult will then be injured by that, of course, because the car is worth less than when they initially sold it to the minor. So that might be a problem where, depending on state law, the minor might have to redress that value gap from the wear and tear upon the vehicle. Now, if that would have been for an item that's necessary for the minor, like food or medicine or that type of thing, that will be a different issue than a non-necessary item. For purposes of determining capacity, intoxicated persons include those under the influence of alcohol but not drugs. This would be false. Intoxicated persons include those under the influence of drugs as well. In regards to contract law, intoxicated includes alcohol and drugs. Guardians may be appointed for which of the following? I believe it's the first one. Only those who are educated incompetent because of a mental illness that impairs the person's ability to care for themselves. I believe that's the correct one. I'll leave that for you to go through your textbook to find. Otherwise, I want to move through these quickly. Executed contract. Contracts move through stages of execution. When a contract first becomes binding upon two parties, that would be when at that point the contract is at the executory stage. That's before either promise is carried out. But then after perhaps one party fulfills their part of the contract first, the contract then is called partially executed. And then when the contract has been carried out fully, the parties then, that is called an executed contract. Contract formation, again, thinking about this from the perspective of a business person or perspective of an attorney trying to prove that there is a binding contract, you want to make sure you're hitting those 4 elements of contract law. Element number 1, that there was an agreement, which is offer and acceptance. Secondly, that there was consideration, some value for both sides. The agreement is that there's capacity between the parties and that the agreement is legal. And this slide here shows 4 different breakdowns. Each of these might be useful depending on your way of thinking in regards to the 4 elements of contracts. There's different terminology for contracts in regards to business contracts and non-business contracts. Some of this is developed from the fact that the restatement second of contracts is the secondary resource utilized by many states and judges in regards to determining what the proper law or outcome is going to be for a contract. The UCC is another type of secondary resource also utilized by legislatures and judges, but is utilized more for the business and large-scale manufacturing style of contracts. It's probably a simplistic way to go about it. One set of particular terminology that I relate to the UCC style of contract is the output contract agreement, whereby a buyer agrees to purchase all his goods from one seller. The agreement, offer and acceptance. It is critical to know that offers must be communicated and must be definite. That is, they must spell out the terms to which the offeree can assent. It must be a manifested willingness to enter into a bargain. Here again, I have another YouTube link at the bottom. Might be helpful to watch that YouTube video. It just restates in a different way these items we're learning, especially in regards to offer and acceptance. This slide here is going over the mailbox rule, which is a timing of acceptance, and also counteroffers. Both are good to go over. So as far as counteroffers, how that works is when one side makes an offer, if the other side, instead of accepting the offer, counters offers, that cancels the initial offer. The initial offer can no longer be accepted by the party that's made the counteroffer. Also, when that second party makes a counteroffer back to the original offeree, the offeree can then accept or counteroffer. And again, if they accept, well, it's binding whatever that counteroffer was, but if they counteroffer at that point, then that second counteroffer and of course the original offer are both off the table, and we only now are coming off of that counteroffer, and that'll go back and forth potentially as the parties are negotiating. But each time you counteroffer, it destroys your ability to accept whatever that original offer was. In addition, acceptances are deemed effective as long as they're transmitted along a reasonable method of acceptance. Whatever means that the offer was presented, typically if you accept back using that same means, that's going to be a fine way to accept. In addition, there's an item called the mailbox rule. Maybe you'll hear about this at some point. This is the idea that in contract law, that if you mail back your acceptance, as soon as you put your acceptance in the mail, that is at the point of time when the law deems your acceptance to have occurred. So it wouldn't be when you sign the contract, it wouldn't be once you put it in the mail and it actually arrives to whoever made the offer. It is when you put your acceptance in the mail. Consideration, quid pro quo. These are some great examples here in the middle. Betty offers to give a book to Lou. Lou accepts. That is not consideration. Lou didn't give any type of bargain for exchange back to Betty. The third example there, Betty offers to give Lou the book. If Lou promises to pick it up at Betty's house, Lou accepts. Again, that is not a binding contract because Lou is not giving any consideration back to Betty. Picking up the book is not enough to equate to consideration. Betty offers Lou the book in exchange for Lou's promise to pay $15. Lou accepts. That would be consideration. That would be quid pro quo. That is two parties giving one another something of value. Again, a great YouTube link there in regards to a bargain for exchange. For a court to enforce a promise, blank must offer consideration. That would be the offeror and the offeree. Consideration detriment, there must actually be a detriment that occurs to both parties. They must be giving up a legal right or benefit. A good example here, one that law school professors love to use to mess people up, trip them up, is one person promises to give another person $50 if the other person promises to do something or to stop doing something that is illegal. So I might say to my brother, I will give you $500 if for 1 month you will stop doing heroin. And my brother says, I agree. I clearly would like for my brother to stop doing heroin. My brother, it might be very detrimental for him to stop doing heroin for a period of 30 days to get the $500. But it's a win-win situation there. Quid pro quo, correct? Well, not in the eyes of the law, because my brother needs to give up a legal right that my brother has, and my brother does not have a legal right to be doing heroin. So to promise to not do heroin for 30 days doesn't work. That is not a legal detriment. Consideration is optional in every contract. False. Consideration is the second element we're concerned with. Consideration needs to be in every contract. Consideration, bargain for. Again, it needs to be a bargain for exchange. It can be a forbearance from doing something, but remember, it's got to be something that they could do anyways. It must be a detriment to the person, not something they were required to do anyways. In addition, you need to watch out for the bargain for exchange where someone attempts to use what's called past consideration. So let's say I've got an employee who works for me. This is a great, super bang-up employee. I love them. I say, employee, you're doing great. I love all your past performance. In a week, I promise to give you $500 for all your past performance. That is going to be just a gift. That is a gift. My employee's past performance is done. That is not a detriment. That is not something my employee has given up. My employee, in fact, already did that work and was to be paid for it underneath their normal salary. So me promising to give them an additional $500 as a bonus, it's a promise I'm making. It's a gift. It's understandable that my employee might expect it, but it's not a contract enforceable under the court of law. Which of the following is what a person will receive in return for performing a contractual obligation? That would be consideration. Which of the following consists of something of value given to another party in exchange for something else of value? Consideration. Which of the following are examples of consideration? That would be the middle one. A promise to do something, a benefit to the promisor, or a detriment to the promisee. All are fine. Promissory estoppel. Again, the magic fairy enters the courtroom and creates a contract. This is going to be something that arises out of the equity of law. An inequity has occurred between two people due to their actions. You're going to have an example where there is no contract. So let's use my employee. They've been doing great. I promised to give them $500 for their past performance. We just talked about that. There's no consideration for past performance. But let's create some inequity here. Let's create some injustice. Let's say my employee is very excited that in a week they will be getting a $500 bonus because, of course, I promised that to them and they've been working very hard. They rely on that promise and they go out and put down a $500 down payment for a cruise. They're going to take a vacation. They did not have the $500 to be doing this, but for the $500 I was going to be giving them. So maybe they took some money they had set aside for rent and utilities, that type of thing, and food, and they were like, hey, it's fine. I can go ahead book this vacation now for $500 because I know my boss in a week will be giving me $500. So therefore I'll still have money for rent and food. It's fine. But then the week goes by and I say, oh, sorry, employee. Not really giving you $500. Sorry about that. There's no contract here, by the way. Well, what has happened here is my employee detrimentally relied on my promise. So let's take a look at the elements that we need to be proven for a promissory estoppel to occur. One, there's a promise from a promisor where they should be reasonably expected to induce the promisee to take action. So here we have a past relationship, right? Boss, good employee. It makes sense the employee would rely on their boss's promise. Injustice, second one, an action or forbearance is taken. Employee did. They acted. They booked the cruise for $500. Third, injustice can be avoided by enforcing the promise. Yes, we can avoid injustice here because the employee would have suffered injustice by not being able to pay rent, not be able to buy food, etc., because of the $500 non-refundable deposit put down on the cruise. An exception to the rule requiring consideration is promissory estoppel. True. There is no consideration for promissory estoppel. This is an interesting example. Feel free to pause and read that. In addition, again, we've got a YouTube video there, which is a good video regarding promissory estoppel and consideration. Another version talking about a similar concept of promissory estoppel is the illusory promise. This is going to be some type of promise that where the law professor is going to be attempting to trick the other party in the test question format. This is something that happens in real life, but I'm trying to think of it from a law school test-taking perspective, which is what we're thinking about. You're taking a business law test, correct? So an illusory promise is one where it sounds as if a party is making an offer or making an acceptance, entering into a contract, but they have created some caveats, some hidden ways where they can worm out of the contract, wiggle out of the contract's terms by not really accepting or not really offering a contract. An example here would be, I would say, hey Hannah, I would like to sell you my bike for $50. And Hannah says, that sounds like a great deal. I will buy your bike tomorrow for $50 as long as I'm feeling good. And I'm like, great. And I take that and I'm like, I'm definitely selling my bike for $50 tomorrow. And I bring my bike and bring it to Hannah the next day and say, here's my bike. And Hannah says, nope, sorry, I'm not feeling good. I'm not going to buy your bike. That's probably a very simplistic example of an illusory promise. But Hannah left herself a wide open, gaping hole there. I'll buy your bike tomorrow for $50 as long as I'm feeling good. What the heck is feeling good? I don't know. How are we going to reasonably determine whether or not someone's feeling good? Is this Hannah's going to tell me whether she's feeling good? How do we check up on this? It is too wide open of a means for Hannah to, you want to talk like rescind or void the contract. There is no contract here because it was a illusory promise, illusionary. Illegal contracts, of course, unenforceable. Statutory violations, violations by public policy, stuff that is illegal. When a contract is voidable, it may be rescinded. Capacity, contracting requires a meeting of the minds. If someone lacks mental capacity to understand what they're assenting to, then often the contract is going to be voidable or perhaps even void. A person who has the mental ability to understand his or her rights and obligations under a contract and understand how to comply with the terms of the agreement is said to have legal capacity. So we've been talking about necessaries. Typically a minor, or perhaps the minor's parents, will be bound to it in regards to making the other person even for the value of the necessary that the minor used. They must be made whole, is the concept, because the minor did need the item, unlike an Xbox or a toy, something the minor doesn't particularly need. A necessary typically is going to be medicine or food. Perhaps an item for school might be a necessary. That is going to be the kind of contract that the minor will likely still be able to, it will likely still be able to be voidable, and the minor will be able to rescind the contract, typically for necessaries, but still you need to make the other party whole for the value. A contract of intoxicated person for necessaries will be enforced for the reasonable value of necessaries. This is a great trick question. Typically, intoxicated persons are going to be liable for the contract. The contract will not be void or voidable for intoxicated persons. Contract law doesn't typically save a person from making a bad deal. It does not. Contract law does not save you from making a bad deal. You can contract yourself into a bad deal, similar to being intoxicated. If you drank yourself into a position where your mental capacity is a little bit hindered by intoxication, the law is not going to save you. The example where an intoxicated person can potentially void a contract would be where the intoxicated person was so intoxicated their mental capacity was hindered in conjunction with the other party knowing that the person is that intoxicated and taking advantage of their intoxication. So really it takes a bad actor on the other side taking advantage of the intoxicated person, and the intoxication person needs to be incredibly inebriated to the point where they don't have the mental capacity, and the other person needs to know that they're that inebriated, that intoxicated. In most states, a minor is someone under the age of 18. True. I'll let you look that over and decide. True. Great one. Contract. Contract, I would think, would need to be written. I just think the word contract law and I think about a written contract, but not the case. Contracts can be oral. Certain contracts, though, do need to be written down. Often you will hear this being described as formalities. Underneath the concept of formalities, the contract needs to be written down, or due to statute of frauds. Statute of frauds will be the types of terminology you'll hear in regards to a contract needs to be in writing. So what types of contracts need to be in writing? Some of this is old law, such as an agreement for marriage needs to be in writing. Another big one is any contract for the sale of land, tenements, rediments, or interest concerning them needs to be in writing. Here's a YouTube video down there in regards to the statute of frauds. Very good. We have the UCC popping up again. The Uniform Commercial Code requires contracts for the sales of goods over $500 to be in writing. Which of the following is false regarding the statute of frauds? Remedies. So we have one side that has breached the contract. How do we redress the other side? Monetary awards, called damages. Monetary awards is going to be money. Specific performance is going to be requiring a party to do a specific action. And restitution, making the other party whole, are three principles in remedies. Compensatory damages is a general category of damages awarded to make the non-breaching party whole. There's a subset of this idea of compensatory damages called consequential damages, which are damages foreseeable that flow from the breach. Here we have an example of a roofer hired to fix a leaky roof, does a bad job fixing the roof. Of course, that's going to cause the homeowner some damage, because they need to have the roof fixed. But then also, if there happen to be a bad rain or storm while the roof is not properly installed, that could cause consequential damage inside the house, foreseeable damages. If the breach causes no loss, plaintiff can still get nominal damages, similar concept under torts, meaning the non-breaching party still wins, but the breaching party might be only liable to pay $5, some low amount of money, something like that. Incidental damages, which include additional costs incurred by the non-breaching party, a reasonable attempt to avoid further loss. Punitive damages are awarded for punishing a defendant in a civil action. Monetary damages, compensatory damages, general damages are divided away from the concept of equitable damages, which is requiring a specific performance, which is an order forcing the breaching party to undertake a specific act. Accord and satisfaction is the concept that we have some type of, potentially we have a contract dispute, but there's an amount of money that is owed. Accord and satisfaction is the idea where a person writes on the check in the memo line that the balance is paid in full. So let's say I owe Chase Bank, my credit card company, $15,000. I pay Chase Bank only $500, but I write on the memo line, paid in full. That is not going to pay my credit card account in full. That is not going to be accord and satisfaction, the writing of a lesser sum of money in order to consider the larger debt paid in full. That is because there needs to be a dispute in regards to the amount of money owed. This would be a credit card receipt, as I said, and I would see my credit card statement and I would see that yes, I made all those charges and there is nothing in dispute there. You're going to see accord and satisfaction perhaps in a business arrangement where things are fuzzier, or the damages that occurred or the breach that happened, that the two parties literally can argue. One person believes I owe you $1,000, the other person thinks it's $2,000. They both have legitimate arguments. There, if one party would pay the other party, we got the $2,000, the $1,000, the one party pays the other party a check for $1,200, writes on there paid in full. At that point in time, the other party cashes the check. Then you can have accord and satisfaction because there was a disputed amount, and the other party should be put on notice when they put the amount on there that that's paid in full, that they're then agreeing because they had the argument, they get the check, says paid in full. At that point in time, you can have valid accord and satisfaction. Everyone, thank you so much for, again, listening to one of our business law videos on the wonderful world of contracts. Sorry that I don't have my children coming in and interrupting us this time. I think people really enjoyed that from the agency law video, but I really want to get these to you so that you're able to utilize them in preparing for the midterm and for your future use. And I think everyone's been doing a great job getting their discussions turned in on time, taking the midterms. I know that some of this is challenging concepts. Some people are coming into these classes, might be their first online classes, and I appreciate everyone putting forth their best efforts. I really suggest please read the comments I put into the discussion notes for every single discussion, especially if you've missed a couple points. I'm really trying to highlight where you can focus to pick up those points, especially if you're getting half of the assignment correct. I'm really trying really hard to guide you, to let you know which way to move forward in order to focus on your reply, the things that you should do, focusing on the discussion questions, the thing you should do. So read that feedback and put it to use. Thank you all. Have a good night.